If you claim you can't have sex as a result of a traumatic car accident, how does the defense truly know whether what you're saying is true? You want to know the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now you've suffered significant injury as a result of a terrible car accident. And now as part of your claim, you are saying that you can no longer have sex or are unable to have sex the way you used to be able to have sex. And that's going to be included in what's known as a loss of consortium claim when you're married. So you're claiming that you cannot or are unable to have sex like you used to. So now during the course of the pretrial question and answer session known as a deposition, which is really pretrial testimony, the defense attorney will have an opportunity to question you about the claims that you're making. And if you are claiming that you're unable to have sex or can't have sex the way you used to, they're going to ask you some really uncomfortable questions about what it is you claim you can or cannot do. And part of those questions will be, Mr. Jones, how many times a week did you have sex with your wife before this accident? And how many times a week are you able to have sex now after this incident? And how painful is it to have sex now? And what positions do you use? And how about if you change positions? And now these are really awkward and really weird questions, very intimate. But the reality is, since you are bringing a claim where you say, hey, I can't have sex the way I used to, they are legally entitled to ask you questions about your sexual history, about your sexual activity, about what you can and can't do. You know, I find that the very best defense trial attorneys are ones who are very sensitive about this topic. And instead of coming right out and asking exquisite details about your sex life and about what you used to do, and these defense attorneys will turn around and ask them in a very subtle way, Mr. Jones, you brought a claim saying that your intimacy has been affected as a result of this accident. Tell me how. And now they'll allow you, the injured victim, the opportunity to tell us in your own words exactly how this has affected you. And now, here's the real question. How do they truly know whether your sex life has dramatically changed? Well, besides you making some comments to your doctor during the course of your medical care and treatment about things you can and cannot do, there's no way for them to truly know how many times a week you had sex before your accident. There's no possible way for them to know how many times a week you have sex now. So why do they bother asking the question? They bother asking it because since you're bringing a claim, now you say that as a result of their driver's carelessness, you suffered all these horrible injuries and it's prevented you from now doing your daily activities, they're entitled to know a little bit more about those activities. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process in a car accident case where you are claiming that you cannot have sex the way you used to as a result of this traumatic car accident. You know, I realize you're watching this because you likely have questions or concerns about your own car accident. Well, if you have legal questions and your matter did happen here in the state of New York, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.